योर लॉर्डशिप की यह कि अमन कुमार पुत्र डॉक्टर संजीव कुमार निवासी पटना कॉलेज के सामने गली में थाना पीर बहोर जिला पटना का रहने वाला है एवं रिश्ता में मेरा मसरा भाई लगता है एवं मेरे घर पर रहकर ITI की पढ़ाई कर रहा था। आज से करीब 1 वर्ष पूर्व मेरे माँ बाप की अनुपस्थिति में जान का भय देकर जबरदस्ती मेरे साथ शारीरिक संबंध बनाया था।
आज से 1 वर्ष
पूर्व लॉर्डशिप
FIR का डेट है
18/11/2017।
सो 1 साल पूर्व मतलब 2016 मान लो,
नवंबर 2016।
यस,
बनाया
नवंबर 2016 में एडमिट।
Supplementary affidavit yesterday, my lord. I have the hard copy if your lordship wishes to see the hard copy. It was uploaded yesterday, my lord, on the web portal.
That affidavit is not on the record.
I have the hard copy if your lordship.
Hard copy of the affidavit.
My lord.
OP number 2.
लॉर्डशिप।
Yes. You are ready to
लॉर्डशिप।
argue the matter?
लॉर्डशिप।
Very good.
My lord, the matter relates to, my lord, determination of age of the petitioner. And my lord,
Take your seat.
on account of, my lord, peculiar circumstances.
Mr. Dayal, why is this that you will occupy the first chair and will not allow the... ये सब चीजें मुझे पसंद नहीं है। कोर्ट रूम में जो लॉयर आर्गू कर रहे हैं उनको चेयर नहीं दें आप। Yes.
My lord, the matter relates to, my lord, determination of age of the petitioner, my lord, who is facing trial before the court below.
Yes.
After the, my lord, completion of the deposition of all the witnesses, a petition was filed for, my lord, holding an inquiry in terms of Section 9 of the Juvenile Justice Act for declaration of the, my lord, petitioner as the juvenile, your lordship. That petition was, my lord, refused without holding any inquiry, on the ground that as per the FIR, it was alleged that the offence was committed several times during the last 1 year, and the FIR was lodged after 1.5 months of completion of age of 18.
What kind of material you are bringing on the record?
My lord, I am bringing on record all the depositions of the witnesses who have appeared during the course of trial, including the informant, and her parents, your lordship. And none of them have made allegation that any part of occurrence took place after the petitioner completed age of 18. My lord. So my humble submission is, my lord, that there is sufficient material for holding an inquiry.
And your age is admitted.
Age is admitted. I have produced my matriculation certificate. As per my matriculation certificate, I have completed age of 18 in the month of October.
Let us come to the depositions.
My lord.
Occurrence is of which date?
Occurrence, my lord, no specific date is given. But as per the, my lord,
No, see, says आज से 2 साल पहले.
My lord.
So
It was recorded on 8th of May 2018. My lord. But that
so
is not
related back to
2016, sometime in 2016.
16. And
Because
what is
there
your
is consistent
and what is your date of birth?
My lord, date of birth is
सर्टिफाइड कॉपी ही आपने लगा दिया सप्लीमेंट्री में.
Lord,
आपने सप्लीमेंट्री में सर्टिफाइड कॉपी लगा दिया पूरा.
लगता है कि
You should have enclosed the photocopy of the certified copy. Anyway, बोलिए.
My lord, the date of birth recorded in the matriculation certificate is 3/10/1999.
3/10/1999. So if it relates back 2 years back, अगर चले जाएं आप.
Sometimes in year 2016.
2016. So in 2016 you will be 17 years old. All right, आगे पढ़िए.
Then, my lord, the last date of the, my lord, alleged offence, that your lordship will find at page 9 of my supplementary affidavit, my lord. Paragraph 4 of the deposition of the informant. That is the part of the examination in chief. In cross-examination, there are other contradictory statements, but this is the part of the examination in chief, my lord, where she has admitted that after 2 months. She fell ill and she revealed all the entire incident to her mother. So that was, my lord, my humble submission is that my lord, thereafter no offence of rape was committed after 2 months. So the my lord, offence completed in the year 2016 itself.
FIR was lodged on which date?
My lord, FIR was lodged on 18th of November 2017. Then your lordship, paragraph 31, page 18, during her cross-examination, she further stated that for 3 months my lord, he had, my lord, relationship with the victim girl. Page 18, my lord, paragraph 13. And thereafter he left, my lord, the house. So no part of occurrence, my lord, took place after that.
In paragraph 18, she is categorically saying,
My lord,
घटना के 1 साल बाद यह दर्ज कराई थी, यह आज से 2 वर्ष पूर्व हुआ था. Therefore, if FIR was lodged on 18/11/2017, therefore, then the occurrence is of 2015.
and that is a, my lord,
And FIR was lodged in 2016.
17, my lord, FIR was lodged. That is the established part, your lordship. And somewhere she says that it was in the summer of 2016. Somewhere she says that it was in the winter of 2016. So there are, my lord, major contradiction. But so far, my lord, for the purpose of holding an inquiry, there was sufficient material before the learned court below. And that my humble submission that I would not to have been, my lord, disallowed.
Yes, come to the impugned order.
My lord. The operative portion, your lordship, starts from page paragraph 8 and 9, your lordship. May I read my?
Yes, पढ़िए.
So in the written report, victim disclosed about the occurrence shows that several times physical relationship with the victim was made by the accused. In the statement under section 164 CRPC, victim has not stated that accused committed rape with the victim continuously. Rather, she has stated that the accused committed rape in the year 2016. Admittedly, as per the matriculation certificate, the date of birth of accused is 3/10/1999. The FIR was lodged on 18/11/2017. Written report and deposition shows that from 2016, several times physical relationship was made by the accused with the victim. Every documented evidence should be read as a whole and in true spirit. Under the aforesaid circumstances, I am of the opinion.
From where is this paragraph 9 finding?
My lord.
From where the learned court below is recording this?
My lord, that
Deposition shows that from 2016, several times physical relationship were made by the accused with the victim.
Position of the informant, my lord. For 3 months, she has stated that for 3 months at and another place.
She says that 2 months after the alleged occurrence,
my lord,
she felt something and then she had disclosed it to her mother.
My lord, but in paragraph 31, she has stated that लगातार 3 महीने.
हाँ ठीक है, लगातार हुआ.
मतलब a kind of continuous repeated nature of occurrence is there, your lordship. But
till it was told to her mother.
Then she told to her mother and my
so
lord,
for that 2 months period,
there may be, my lord,
it was continuously.
I have also, my lord, annexed the deposition of the mother and father, and from their deposition also, my lord, it is clear that the occurrence, my lord, was limited to a period of 2-3 months in the year 2016 only. At page 31, your lordship, paragraph 15, the deposition of the father, my lord. He has also stated that after, my lord, 6 months he came to know about the love letters, my lord, and then he inquired into the matter.
उसके मदर का कहाँ है डिपोजिशन?
My lord, mother deposition starts at page 25, my lord.
यस, बोलिए।
लॉर्डशिप पहली बात ये तो उनके मौसेरा भाई हैं लॉर्डशिप।
कन्फाइन योर आर्गुमेंट टू द मटेरियल्स ऑन द रिकॉर्ड।
लॉर्डशिप एफआईआर लॉर्डशिप एफआईआर में है लॉर्डशिप की यह कि अमन कुमार पुत्र डॉक्टर संजीव कुमार निवासी पटना कॉलेज के सामने गली में थाना पीर बहोर जिला पटना का रहने वाला है एवं रिश्ता में मेरा मसरा भाई लगता है एवं मेरे घर पर रहकर आईटीआई की पढ़ाई कर रहा था। आज से करीब 1 वर्ष पूर्व मेरे माँ बाप की अनुपस्थिति में जान का भय देकर जबरदस्ती मेरे साथ शारीरिक संबंध बनाया था।
आज से 1 वर्ष
एक वर्ष पूर्व लॉर्डशिप
एफआईआर का डेट है
18/11/2017।
सो 1 साल पूर्व मतलब 2016 मान लो।
नवंबर 2016
यस,
बनाया था।
नवंबर 2016 में एडमिटेडली ही वाज माइनर।
लॉर्डशिप उसके बाद लगातार अनेकों प्रेम पत्र देकर मुझसे प्यार करने एवं शादी करने का झांसा देकर पिछले 1 साल से लगातार नाजायज शारीरिक संबंध बनाता रहा है एवं शादी करने से इनकार कर रहा है। उसके बाद लॉर्डशिप जान मारने की धमकी देता है। ये सब आया है।
अब आइए डिपोजिशन। डिपोजिशन में आइए। पैराग्राफ 4।
इस कांड के 2 माह बाद मेरी तबीयत खराब होने लगी। अचानक बाथरूम आने लगा तो मेरी माँ मुझे डॉक्टर के पास ले गई। डॉक्टर ने 5 जांच कर बताया कि मेरी बच्चेदानी का मुंह खुल गया है। तब जाकर मैंने मम्मी को सारी बातें बताई।
सो शी इज सेइंग कि only after 2 months of the alleged occurrence she had told this to her mother. Now if this is to be taken into consideration, then it may be held perhaps that the mother had come to know about this occurrence after 2 months of that, and by that time this petitioner was a minor.
But on FIR lordship उसमें लिखा है कि लगातार इन्होंने 1 वर्ष मेरे साथ
ये कर रहे हैं ना। अब तो एफआईआर से आगे की बात हो रही है
लॉर्डशिप। और
अब
उस
तो
समय
ट्रायल क्वेश्चन ये है कि क्या ट्रायल में कुछ ऐसे मटेरियल हैं जिसके आधार पर इस विषय पर इंक्वायरी करने की जरूरत है। इतना ही क्वेश्चन है। दिस कोर्ट इज नॉट गोइंग टू डिटरमाइन द जुवेनिलिटी ऑफ द पिटिशनर हियर। The submission is that there are verifiable materials, there are sufficient materials which require a consideration of my application.
और सिर्फ डिपोजिशन के अनुसार तो he became major. On that time he is minor. 2 महीने के बाद तो ये माइनर थे। ये तो
थे ना। तो 2 महीने बाद जिस दिन मदर को पता लगा उस दिन तक ये माइनर थे। अब आगे आइए।
उसके बाद वही लॉर्डशिप जान मारने की धमकी देते रहे मोबाइल से।
वो सब कहानी बात की है। पहले इसमें देखिए ना, प्रति परीक्षण में आइए। पैराग्राफ 18।
प्राथमिकी मैंने ही दर्ज कराई थी। घटना के 1 साल बाद यह दर्ज कराई थी। यह आज से 2 वर्ष पूर्व हुआ था।
आज से 2 वर्ष पूर्व हुआ था। तो 2 वर्ष पूर्व, 17 से 2 वर्ष पूर्व अगर चले जाइए आप, या जिस दिन, सॉरी, जिस दिन डिपोजिशन हो रहा है उससे 2 साल पीछे चले जाइए,
18
तो इट विल गो बैक टू 2016। एंड ये भी सही है कि घटना के 1 साल बाद FIR हुआ, और घटना के 2 महीने बाद इसने अपने मदर को बता दिया। ये तो क्लियर है इनके डिपोजिशन से, तो इसको क्यों नहीं कंसीडर किया कोर्ट बिलो ने? Both were at the time of alleged occurrence, as it appears,
both are minor loss.
both were minor. It should have been considered. लिखिए, heard learned counsel for the petitioner and learned counsel for the opposite party number 2. Who appears for the state? Who is the learned advocate?
Mukesh Kumar.
As usual, the learned advocate who has been assigned the brief on behalf of the state is not present. And on the request of this court, Mr. Akleshwar Dayal, learned APP, has represented the state. कुछ कहना भी है आपको? Okay. Petitioner in the present case is aggrieved by and dissatisfied with the order dated 8/4/2021 passed in special case number so and so, by which the learned additional session judge 6th cum special court Pakso Patna has refused to consider the claim of juvenility of the petitioner in the light of the materials which have come in course of trial in form of deposition of the victim girl. Full stop. Next, learned counsel submits that admittedly the petitioner, the date of birth of the petitioner mentioned in his matriculation certificate is date of birth
3/10/1999.
3/10/1999. Full stop. The allegation against him is that while staying in the house of his Mausi for purpose of studies, he committed rape on her Mauseri sister. Full stop. The victim alleged that the rape was committed regularly. Full stop. Next, learned counsel for the petitioner submits that on a bare perusal of the first information report, it will appear that the victim had alleged that about 1 year ago, the petitioner had established relationship with her by threatening her, and thereafter he continued with the said relationship on the pretext of marriage. Full stop. It is submitted that the FIR has been lodged on 18/11/2017 and the alleged occurrences as per the FIR that of the year 2016. Full stop. In the year 2016, the petitioner was a juvenile. Full stop. Next, it is his further submission that in the FIR, there is no disclosure that the alleged act had been committed till the date of lodging of the FIR. Full stop. The allegation that the petitioner continuously made physical relationship with her would not lead to a conclusion that the relationship was continuing till the date of lodging of the FIR. Full stop. The petitioner attained majority only on 3/10/2017. That is 1.5 months prior to the date of lodging of the FIR. Full stop. Next. It is a submission that under the above circumstance, the petitioner was advised under the above circumstance, the prosecution of the petitioner continued. Full stop. In course of trial, the victim girl appeared for her deposition on 8th May 2018. Full stop. She stated that the alleged occurrence had taken place with her about 2 years ago. Forcibly. And thereafter, on many occasions, the alleged acts were committed with her on the pretext of marriage. Full stop. The petitioner was also writing love letters to her. Full stop. In paragraph 4 of her deposition, she has stated that after about 2 months of the alleged offense, when she had some medical issues, then she had gone to the doctor and had disclosed the entire things to her mother. Full stop. Next, Learned Counsel has further drawn the attention of this court towards her statement in paragraph 18, where in course of her cross-examination she has stated that she had lost the FIR 1 year after the alleged occurrence and 2 years from the date of her deposition. Full stop. Next, client counsel submits that even though these materials were present on the record, the learned trial court has not at all looked into these materials and proceeded to reject the application of the petitioner by merely taking note of the allegations in the FIR and her deposition and her statement under section 164 CRPC. Full stop. The trial court has not considered the entire deposition of the victim, which is available on the record. Full stop. Next, client counsel for the opposite party number 2 has, though opposed this application, but at the end, client counsel admits that these materials which are indicated herein above on behalf of the petitioner have not at all been considered. Full stop. Next, having regard to the submissions noted herein above and the materials available on the record, this court finds that the deposition of the victim girl has not been considered in its entirety. To consider the claim of juvenility of the petitioner. Full stop. Certain paragraphs of her deposition have been placed before this court, and those have been indicated herein above, which lead to a prima facie view that the application claiming juvenility of the petitioner is required to be considered afresh, keeping in view her depositions, keeping in view the depositions of the victim, particularly that after 2 months of the alleged occurrence only, she had felt some trouble and then was taken to a doctor where she had disclosed everything to her mother. Full stop. Client counsel for the opposite party number 2 has agreed to this extent that at least till that date, that is 2 months after the alleged occurrence, the petitioner was a juvenile. Full stop. The FIR has been lodged 1 year after the alleged occurrence. Therefore, these are the material facts which are required to be considered by the learned court below. Full stop. Next, in result, the impugned order dated so is hereby set aside. Full stop. The matter is remitted to the learned court below for giving a fresh consideration to the plea of juvenility of the petitioner after giving adequate opportunity of hearing to both the sides. Full stop. Let it be recorded that the observations of this court herein above are only for the purpose of this case and the learned court below shall exercise its own judicious mind independently. Full stop. This application stands allowed to the extent indicated here.
लाइन में इसमें सेक्शन 9(2) के टर्म्स में इंक्वायरी का था जो जुवेनाइल जस्टिस
Actually,
तो एक खाली वही इंडिकेट कर दिया था कि इन टर्म्स ऑफ
consider the
सेक्शन
application of phrase for purpose of an inquiry in terms of subsection 2 of section 9 of the
Item number 2.